Dr. Ebony Birchall. I'm a lecturer at Macquarie University in Sydney. So I'm now an academic, but I did spend 12 years working as a human rights class action lawyer before becoming an academic. And I still, even though I do academic work now, I do a lot of research and teaching now, I still try to do practical legal assistance as well. So the research I'm going to talk about today, it's research that we're doing through the Business and Human Rights Access to Justice Lab. And I run this lab with my colleague, Professor Surya Deva, who I think Susie's just mentioned to you. But I just wanted to start by acknowledging his work because, this research that I'm talking to you about today is very much his work as much as it is mine. And so as part of the work that Surya and I do in the Access to Justice Lab, we research and create resources and try to build capacity and offer pro bono assistance as well to rights holders. So that's a little bit about me and the work that I'm doing. Now, I can see that Susie has shared the co-hosting rights with me.
Yes.
So I'm just going to try and share my screen. So what I've done here, I hope this works because I've never done this before, but because there's a bit of a language barrier, I wanted to try and make my presentation as helpful as I could. So what I've done is I've created these slides, and on the left, I've got the English version, mainly for my purposes. And on the right, I've got translation into Spanish there. Now, I should warn you that I've just done this translation off Google Translate, so it could be wrong. There could be grammatical errors, so I'm sorry for that. But hopefully this visual presentation might help to keep people engaged and up to where I'm talking about. So, and I did want to say that I'm sorry I couldn't be there in the room with you. I'm in Bangkok for a conference. It would have been much better to be there. And I also wish that I could be speaking your beautiful language as well. So please forgive me for speaking English. And I wanted to thank the interpreters that we've got. Please let me know if I'm talking too quickly or anything like that as I go through. So I will start my presentation. So what I'm talking to you about today is some mechanisms that rights holders can use to pressure businesses into doing the right thing. So in the research that Surya and I are doing, we're using the term justice lever instead of mechanism. It's essentially the same thing. It's just how can we put pressure on businesses to try and achieve justice? So this research that I'm talking to you about today, we're in the process of publishing this at the moment. And what we're doing is we're creating a guide on each of these justice levers. And we're hoping that that will be published by the end of this year. And this document that I've got on the screen here today, I'm going to share it with Susie after this presentation. So if you see anything on the screen and want to write it down or whatever, I just wanted to mention that I'll send it to Susie so you can get a copy of it. And of course, by the end of this year, hopefully you'll have the actual proper resources that we plan to produce. And we're hoping to have those guides translated into other languages. So watch this space. Hopefully by the end of the year, those guides will come out. It's obviously a big project. It's been a lot of work to get this type of information organized. So today we're going to be talking about 6 different mechanisms. So these are the mechanisms that I'm going to talk to you about. The first one is national contact points, and then national human rights institutions, and shareholder activism. I'm going to talk briefly about UN special procedures because I understand that you might have already done a session on that mechanism, so I won't spend too long on that. And then we'll talk about benchmarking and also civil society advocacy. So my aim today is to basically give you a high-level overview of these justice levers, or mechanisms that you can use to put pressure on businesses. So I'm not going to have enough time to go through each of them in detail and analyze how effective they are and that kind of thing. But the idea is that I can introduce you to these mechanisms and give you some ideas. And hopefully from there, you can go away and do your own research and think about how you could use them. When I go through, I'm going to go through each of these mechanisms now, and I'll provide a bit of an overview, and I'll provide a bit of a case study or an example of how these mechanisms have been used. And I've got a couple of links here for more information if you wanted to go off and get some more information about these mechanisms. And I wanted to say from the start that none of these mechanisms, sadly, are a complete answer to providing justice. It's obviously not a quick fix, as we all know, working in this space. And each of these mechanisms won't necessarily apply in every circumstance. So you need to be thinking about the circumstances that you're in, which mechanism is the best to use, which mechanism is actually available to you, because some of these mechanisms only work in certain circumstances. And what we've really found in our research is that it's the most powerful thing you can do is actually to use multiple of these mechanisms. So if you combine several mechanisms at once, it generates more pressure than just doing one mechanism. And that comes up in some of the case studies I'll talk about. You can see where a couple of these mechanisms will work together, and we'll get into more detail later, but civil society advocacy, the last one we'll talk about, basically is useful alongside each of these other mechanisms. So yes, so it's, I don't want to present them to you as, answers to the problem and, just do a national contact point complaint and everything will be fine. It's not like that. This presentation is more about just giving you some ideas about different options that are out there and that have been used in some cases, and where in some cases it's had some impact. Yep. Okay, so the first one, here's my introductory points. Should have moved on earlier. Anyway, this is what I've just said, that today's aim is just to introduce you to these ideas. Oh, the other point that, I didn't mention, some of them are more direct than others. So some of them are more direct remedial mechanisms. So for example, the national contact point, you can actually issue a complaint and you get the national contact point to investigate. So that is what I would say is a more direct remedial type mechanism. And then some of the other mechanisms that I'll talk about today are less direct. So things like civil society advocacy, for example, it's not a mechanism where you make a complaint and a investigative body investigates. It's less direct. It still creates some form of pressure on the businesses, but it's not that sort of remedial mechanism like some of the others. So yeah, each of the mechanisms are slightly different, as you will find out as we go through. Okay, so the first one is national contact points. So national contact points, these are linked with OECD guidelines for multinational corporations. So basically, once a state signs up to be part of the OECD guidelines for multinational corporations, they have to create what they call a national contact point. And a national contact point is essentially a body that will hear complaints about corporations. And basically, you can make a complaint about a company if they're not observing the OECD guidelines. So that's the point of the national contact point. It's there to take complaints about corporations who are breaching the rules that are set out in the OECD guidelines. So who can make a complaint to the national contact points? So the answer to that is any interested party can make a complaint to a national contact point about a corporation. The thing you need to think through, though, is which national contact point do you actually make a complaint to? Because, as I said before, every state, so every country that is adherent to the the OECD guidelines, they have to create a national contact point. So now we've got about 51 national contact points around the world. So each country will create their own national contact point, their own agency. So you have to figure out which agency or national contact point to actually lodge your complaint to. And the way that this works is you think about the company involved. So if the company is an Australian company, as in it's headquartered in Australia, then you could make a complaint to the Australian national contact point. Or if the company is operating in Australia, then you can make a complaint to the Australian national contact point. So you have to think about where is the company headquartered, and where are the business activities of the company. And that's the national contact point that you then approach. Now, there's some strategy in this, because you can actually contact more than one national contact point. So you could, let's say there's an Australian company operating in Colombia, that opens up two national contact points that you can make a complaint to, because you can complain to Australia because it's an Australian company, but because this business is operating in Colombia, you can also complain to the national contact point in Colombia. So there's a few things to think about there. The other thing you can think about is there's also the ability to complain about companies that are involved but might not necessarily be the main company. So, for example, if a mining company is doing the wrong thing, you could find out which banks are actually financing the project. And then you could complain about the banks involved. So it's not just the main company that you can complain about, but you can also complain about other influential companies involved. So, and again, there's some strategy in that, thinking through which companies are involved and which national contact points you can actually make a complaint to. So, some of the advantages with a national contact point complaint is that it's a more direct pathway. As I said before, it's one of the most direct mechanisms that I'm going to talk about today, because what happens is you make a complaint, and then the national contact point will investigate, and they can do a mediation process where they get the rights holders and the company to mediate the matter and discuss. And this mechanism has led to outcomes where rights holders have been compensated or other remedies have been provided. So, as I say, it's a more direct form of mechanism. One of the other advantages is its broad reach. As I said before, these national contact points, they can hear complaints about businesses within their country, but also they can hear complaints about companies that are headquartered in their country that are operating overseas. So they've got quite a broad geographic jurisdiction. And they're quite accessible, these types of complaints, because generally, it doesn't cost money to approach the national contact point. And often the national contact point will do their own investigations, and yes, so it's quite accessible. You can approach them and ask them to do investigations. The only caveat to that is some national contact points will require more evidence from the rights holders before they will consider a complaint. So in those cases, it becomes a bit less accessible because they will ask you to do certain investigations, which might require resources. But for the most part, it's quite an accessible, low-cost mechanism. The disadvantages with the national contact point complaints are that it is what we call soft law, so it's not enforceable. The rulings or the findings that the NCP, the National Contact Points, make, they're not enforceable. They can't force a company to follow their recommendations. And there's also some disparity between the different national contact points around the world. So some are more responsive and than others. And some national contact points do have a conflict of interest where they might be situated within governments, and therefore, as we know, the influence of governments can make the mechanism less effective. So there are some disadvantages there, that we need to be aware of. Now, what I've done here in this slide, I've just put an example in case anyone wanted to look it up and find out more. But this example, we're referring to it as Equitable Cambodia and Inclusive Development International and ANZ Banking Group. So this is an example where a group, a large community of Cambodian farmers and families were displaced from their land because of a sugar plantation. So what happened here was ANZ Bank wasn't the actual company involved that was doing the displacement and the business activities, but ANZ Bank financed that company. And so what happened was the families involved, they made a complaint about the bank, and the ANZ Bank engaged in this national contact point complaint, and eventually they made an agreement that all of the profits from that project would be given to the community to try and remedy some of the hardships that they've been through. So that's just one example of how this mechanism can produce results. And I've just got a link there as well. If you want more information, the OECD Watch website is very helpful. It's got fact sheets and guides on how to make an NCP complaint. And they also have, I found this really interesting, they have evaluated the effectiveness of the different NCPs around the world. So that can give you some insights into the different NCPs, because as I said, some NCPs are more responsive than others, and some NCPs have problems with being situated within the national government and that kind of thing. So they have some good information there that you could do some more reading about if you're interested. Okay, so we'll move on to our second mechanism now. And the second one that we're talking about is what we refer to as national human rights institutions. So sometimes we refer to these as NHRIs for short, but they're essentially an institution set up within each country that is supposed to promote and protect human rights. So there's actually a UN agreement called the Paris Principles, and that UN Paris Principles agreement, it provides guidance to national human rights institutions on what they should and shouldn't do. And these UN principles try to regulate national institutions to some extent by assessing national institutions to work out whether they are complying with these Paris principles. So there is some regulation there at the international level about what national human rights institutions should do, and some guidance. But of course, like most things at the international level, each country varies, and there's differences between one country to the next. And some of these NHRIs are called commissions. Sometimes they're called ombudsmen. So each country really has a different way of setting up a national human rights institution. But the whole purpose of these institutions are to promote human rights. And some are more effective than others. Some have different mechanisms that they use. So some institutions will report and monitor human rights situations. Some institutions have a judicial function and can actually hear complaints. And the other thing that is different between each country is the way that it treats corporate behavior. So some national human rights institutes, their jurisdiction says that they can only deal with complaints about government activities and not corporate activities. So that's something to be aware of as well. If you're investigating a national human rights institution, you would need to look into the jurisdiction of the institution and whether it has jurisdiction to investigate corporate activities. Yes, because that's a major barrier in this space when holding corporations to account, that some of these institutions don't have jurisdiction. So some of the advantages of national human rights institutions, if they're working effectively and properly, then these institutions can apply reputational pressure, regulatory pressure. They can do consultations and reporting, and they can engage with governments and provide advice to governments on human rights issues. So there are some, good case examples of these institutions having impact. However, on the flip side, the disadvantages, these institutions, they often face jurisdictional constraints, as I mentioned before. Some do not have jurisdiction to investigate corporate activity. They're only able to investigate government activity. Some of them lack enforcement mechanisms. And of course, again, there's a big variance in independence and resourcing of these institutions across the world. So some countries' institutions are better than others. But I've just provided an example on the screen about the Mongolia NHRI. That particular institution has powers to conduct monitoring and reporting on mining activities, as an example, and other corporate activities. And it's also empowered to instigate public interest litigation in certain circumstances as well. So you can see here how some of these institutions do have quite a bit of power and have the ability to make impacts on corporations. Now, I'm not familiar with the Colombian system and whether there is an NHRI and how effective that is. So I'm not sure if someone else there might have any experience, but maybe we can explore that when we get to our question time a bit later. So the next mechanism is shareholder activism. So the idea with shareholder activism is that advocates, human rights defenders, rights holders, that if they can influence sympathetic shareholders, then shareholders do actually hold a bit of power to influence corporate activity. So the idea here is, shareholders have bought shares in a company. So they've invested in a company. And because they have this particular role within the company structure, they're actually part of the company structure. They have rights and privileges to access company information, to engage with companies, with, at board meetings, at general meetings, that kind of thing. So they have particular rights that if advocates can influence these shareholders, then it's a way to put pressure on corporations. So that's the general idea. Now, there's a lot of different ways that shareholder activism can occur. So I won't go through all the different ways, but I'll give you a bit of an example. So the example is about a Norwegian government pension fund called Norges Bank. I'm probably pronouncing that wrong because I'm not great with languages. But basically, this pension fund, it has an ethical mandate. So it is very strong on the idea that they will only invest in businesses that are doing the right thing. And if they see that one of the businesses that they've invested in has done the wrong thing and is, complicit in human rights abuses, then they'll actually engage with that business and say, hey, we've seen that you're doing the wrong thing here. Can we have some meetings? Can we come and do, monitoring of your factories and farms? And they basically use their role as a shareholder to hold these companies accountable. So in one particular example, it was reported to this pension fund that an Indian corporation called UPL, they produce seeds. There was reporting that this corporation was using child labor in their farms and in their processes. So what the pension fund did was they said to this company, we've flagged you as a corporation that's doing the wrong thing, and we're going to put you on a 5-year monitoring plan where we expect to see improvements. We don't want to see child labor in your farms. And over the course of 5 years, the pension fund went out and actually monitored their farms. So went and did inspections and spoke with workers and spoke with the executives of the company. And over the course of 5 years, the company implemented policies and programs to remove child labor from their workforce. So that's just one example of how shareholder activism can work. There are other examples. So, shareholders can say to a company, if you don't change your policy on this issue, I'm going to withdraw from the company and sell all my shares. And that's going to impact, your share price. Or in another form of shareholder activism, shareholders can put forward a vote at a company meeting to say, we want to vote to have this policy changed. So as I say, there's multiple different ways of how shareholder activism can actually work. The big challenge here is obviously finding shareholders that are sympathetic to the issue that you want to advocate on. The other big challenge is actually figuring out who are the shareholders in the company that you're dealing with. So it's not straightforward, it's not easy, but if you can find sympathetic shareholders, then it is a powerful tool because you're dealing with people who are actually inside the corporation and have, and it can be quite powerful. So that is shareholder activism. Now, the next mechanism As I said, I'm just going to deal with this briefly because I understand that you've got a different session to talk about this. But UN special procedures. So the UN Human Rights Council have a body of independent human rights experts, and they have different mandates. So they have different roles. So, for example, Surya Deva, who I mentioned before, who's the director of the lab that I work with, he has a mandate. He is a UN Special Rapporteur for the Right to Development. So, in his capacity, looking at the right to development, he runs consultations about the issues around the right to development. He writes reports. He does country visits. He gets complaints written to him in his capacity, and he writes letters to governments about human rights situations. So the idea with UN special procedures is to leverage the influence of these independent human rights experts by making a complaint to the particular human rights expert and asking that expert to advocate on an issue. So there's quite a lot of information on the UN Special Procedure website on how to make a complaint. It's quite easy. You make the complaint on the website. There are some guides and fact sheets about how to do that. So again, I've posted the website link there, so you can do more reading if you want to find out more information about that. And the next one is benchmarking. Now, this one's a bit interesting and often doesn't get brought up in other conversations about mechanisms for access to justice because it's not a direct mechanism. It's not a complaint function. But I find it really fascinating, and it does have potential to improve business conduct. So I'll explain a little bit about what this is. So benchmarking. So this is where companies are assessed on their human rights compliance and performance, and organizations write reports to basically rank companies on how well they're doing with their human rights compliance, and they'll get a ranking out of each. There's a lot of benchmarking reports out there. It's not just one particular benchmarking report. There's a whole range of organizations who are doing these benchmarking reports. The most famous in the corporate area is called the Corporate Human Rights Benchmark. So CHRB, sometimes people call it the CHRB for short. Now, this benchmark, it's produced by the World Benchmarking Alliance. I've put the link to their website with more information on that corporate human rights benchmark in case you want to read more. But what they do is they can't benchmark every company in the world because that's obviously ridiculous amount of companies. But they pick the biggest companies in the world, and periodically, so every year or two, they will issue a report that lists all of the top companies that they've assessed and what ranking that they've got. And there's a whole set of criteria that they rank these companies on. And the criteria is created by looking at the UN guiding principles, so the UNGPs. So the whole idea of these benchmarking reports is to say, the UNGPs, they outline a whole list of things that corporations should do, but corporations often don't know how to actually implement the UNGPs. So these benchmarking reports create a list of actions that these that these corporations should do, and they essentially assess whether or not these corporations are implementing the UNGPs. So it's a really helpful way for businesses to get clarity on what exactly their human rights expectations are. And it's also a good way to track progress towards the UNGPs, because what happens is a lot of these companies rank very poorly. So I've actually, I'm doing a project at the moment where we are ranking Australian companies based on the same criteria and methodology from this corporate human rights benchmark. And our results show that Australian companies are rated very poorly. They're not doing very well at complying with the UNGPs. So the reason that this benchmarking report becomes powerful is once our report is published, we can take that report to the Australian government and say, these companies are not complying with the UNGPs, and therefore we need mandatory laws that say companies should do X, Y, and Z to try and force companies to comply with the UNGPs. So it's a way to sort of track performance of individual companies, but also companies across the nation and across the world, on how well they're doing in terms of human rights compliance. These benchmarks are also really powerful because they incentivize improved performance, because it creates a competitiveness within industries and between corporations. So if one big mining company sees their competitor is ranking above them, then it creates a race to the top. It promotes competitiveness. And what we've found is that these corporations, they do actually care what these rankings show, because the media is really interested in these rankings, because whenever you get something that's a tangible number, this company is coming first, this company is coming last, it often creates media attention, and businesses care, well, public-facing businesses care about their reputation. Some companies don't care about their reputation, particularly if they don't have a public face. But for the most part, what we've seen is that corporations are actually quite responsive to these benchmarking reports and do want to improve their performance. So, and the last way that benchmarking helps promote human rights is that the benchmarking report itself promotes multi-stakeholder dialogue. So as I said before, once we publish our report on Australian companies, we plan to use that report in dialogue with the companies themselves, but also the government. So, we're writing to companies and saying, hey, we've assessed you as scoring, 2 out of 20 possible points. This shows that you need to implement X, Y, and Z policy. And that is a way of us creating a dialogue with these companies. And as well, like I said before, it's a way for us to create a dialogue with the government. Now, I've got a couple of examples on how these benchmarking reports can be used. So the first one is Kraft. So the company Kraft, I don't know if Kraft have goods in Colombia, but in Australia, Kraft produce, I think it's cheese or something. Anyway, it's a big company. And basically what happened was, in the CHRB, in the 2017 report, they scored really poorly. And so some of the investors in Kraft saw that poor rating, and they issued a shareholder resolution asking the corporation to produce a report on its human rights due diligence and performance because they wanted answers on why the company was rating so poorly. So you can see here how these benchmarking reports can be used by activists to then put pressure on the company. And as I said earlier, this is a good example of how some of these mechanisms can work together. Because in this example, we've got the benchmarking report that's part of the picture, but we've also got shareholder activism here where the investors are putting pressure on the company because of the poor benchmarking result. So that's one example. The second example I wanted to give you was about an Australian mining company called Rio Tinto. So Rio actually got quite good results in the CHRB, which surprised a lot of people because Rio doesn't have a good reputation in the human rights world. And so there was a bit of media attention to begin with about their good rating. But then what happened was Rio was involved in a situation in 2020. The company detonated caves at Yukon Gorge, which is a sacred Aboriginal site in Australia. It has a lot of cultural significance, this site. So it was, a really poor corporate behavior. And so advocates wrote to the CHRB, the benchmarking organization, and requested that Rio be stripped of its ranking because they say that this event shows that actually Rio is not performing well with their human rights. And this whole event attracted attention, and the advocates wrote an open letter that was published in the media, and actually Rio responded publicly and issued a statement about the situation. And what happened was the benchmarking report eventually decided to issue a statement condemning Rio's behavior. And they have appended a statement about the situation to the most recent benchmarking results, so that anyone reading the benchmarking report can be told about Rio's poor behavior. So, and the CHRB, they're doing work in this area. They've come under criticism because of situations like this, where Rio has received a positive top score for their human rights performance. But then at the same time, there are situations like the destruction of cultural sites. And so obviously it shows that their benchmarking methodology isn't perfect and doesn't always produce perfect results. And the organization involved, the benchmarking organization, they are trying to improve their processes to better recognize these human rights events that occur. So it's not a perfect mechanism, like all the others aren't perfect, but it does produce just another way to create dialogue, create engagement with companies, create some media attention around corporate activities. Okay. Now, the last one that we're going to talk about is civil society advocacy. Now, this is a very flexible and dynamic type of mechanism. We see civil society advocacy everywhere. There's lots of different kinds of advocacy that you can do, things like social media campaigns, petitions, writing newspaper articles or documentaries, doing research reports, all of these mechanisms and ways of doing advocacy, it's all about raising awareness to an issue, trying to put reputational pressure on a company, trying to inform society about what's happening. So this is not a direct mechanism. It's not a remedial mechanism in the way that a complaint procedure is, but it's another way to put pressure on businesses. And last year I published a report on maximizing the impact of strategic litigation on corporate behavior. So how can we make sure that strategic litigation against corporations is having maximum impact, and promoting human rights as best as possible? And one of our findings was that strategic litigation alone can be powerful, but actually the most powerful way to use strategic litigation is to use it alongside complementary strategies like civil society advocacy. So and this is the real benefit of civil society advocacy, is that it complements other mechanisms, and it maximizes the impact of other mechanisms that we've spoken about. So I would encourage you, when you're thinking about what mechanisms to use in any type of campaign, I would encourage you to be thinking about how can we use several mechanisms at once, and how can we strategically use civil society advocacy to try and produce the most impact. Okay, so that brings me to the end of the mechanisms that I'm talking about today. This last slide, I just wanted to put some contact details here in case anyone wanted to connect with me. As I said, I will be providing this document that I've just been reading through. I'm going to provide it to Susie so that she can disseminate it to everyone there. So we have a website about our Access to Justice Lab that talks a little bit more about our projects. You can also find me on LinkedIn or X, which used to be called Twitter. On the actual document, there's links to my actual LinkedIn page and Twitter page, so that you can easily follow me. The reason I'm suggesting that you find me on social media is that whenever I produce a research report, like some of these guides that are coming out later this year, I will post them on my social media accounts. So following me is a good way to get access to any of those resources that we publish in future. And that report that I just mentioned on strategic litigation and maximizing the impact of strategic litigation, that's available on our lab website if you want to look on that.
Okay.
Yeah.
Ebony, muchas gracias. Many thanks. Shall we do a round of questions? ¿Hacemos una ronda de preguntas?
About the NCPs, the national contact points, where you were telling us that by involving the bank, you got them to instruct that with the profits, the company would have to do a remediation. But were you able to stop the project from continuing to be developed? I mean, if a community is defending its territory to stop its destruction, what's the point in getting remedies, let alone with the money that they're receiving from the destruction of their territory?
Yeah, so what the complaint did was it raised awareness. It didn't stop the human rights abuses had already occurred by the time the complaint was made. And in this situation, it was the ANZ Bank. So it was the bank that was actually responsive to the complaint, and offered some form of remedy to the community involved. It wasn't the actual business. It was Phnom Penh Sugar. It's a Cambodian business. It wasn't actually the business that stopped their activities or provided remedy. It was the bank involved. And the bank stopped working with the sugar company. But of course, the sugar company can go off and get another bank if they want. So, as I said, it's not a perfect answer, but getting compensation and help for the affected communities to try and help alleviate their hardship, it's better than nothing. But as I say, and as you've pointed out, it's not a complete solution. Yeah, it's really hard, and I wanted to acknowledge that right at the start of my talk, that none of these mechanisms are perfect. And like you say, corporations are very sneaky, and they'll do whatever they can to get out of accountability, like doing things like selling off assets and all that kind of thing. So it is very difficult. There are examples where these strategies have worked. And the thing that I've noticed doing this research is a lot of people aren't using these strategies or don't know about these strategies. And there's not much information out there about how to use these strategies effectively. So this research that we are doing is aimed at trying to get more information out there. And I haven't gone through everything that will be in these reports that we're publishing later this year, but part of the reports is to look at strategies that make each of these mechanisms more effective or not, and in which circumstances which strategies are going to be more effective. So we are trying to do that analysis work of making these mechanisms a more targeted strategy rather than just a shooting gun, like you said, because I do appreciate that using all of these mechanisms takes resources and time, and often we don't have resources and time. And that's part of why we're doing this research, is to create a more strategic way of using these mechanisms. Yeah. I don't know if that answers your question or helps.
Any question? Thank you. I wanted to contribute, maybe from my experience in the Department of Putumayo, in terms of what's happening to us and what they want to happen in our department. We have taken one of the rulings of December 2023, which is deemed unconstitutional, and the court orders the national government, this Colombian state, or how to protect within the participation mechanisms, such as development plans, or the municipal development plans, department plans, all actions, budgets, and functions related to investment should have a focus on human rights. And so in that regard, if we don't have that, if that ruling, it gave them 6 months to a year to demand as of now. Let us read that ruling, and of course, based on human rights, which are third and fourth generation, which is the right to an healthy environmental, which is not territorial because it's global. We are at least, we're close to the destruction of land, our common home, and we have basic plans of land planning that due to ruling 4360, they should be adjusted and updated, because they're very much behind the 20, 30 years in some municipalities. They don't even exist. And lastly, what happened to us in Mocoa in the avalanche of 2017, we can protect ourselves with another mechanism, which is the plan and management of the basin, which coincides with the national planning plan, power, world power for life. So each municipality, each territory, each hamlet or township, they have water, they have a creek, they have their own an aquifer, the groundwater, even rainwater, that it should be protected. That's really how to protect everything that is related, so as not to really begin to file complaints, but to be ahead of that. And even in your house, in your own community, you can protect your community by begging the environmental society that have a national reservation for social for civil society. If you have an endemic tree, for example, and the mining company of Liberaco, they did not only use 8,000 hectares, but they have 100,000 hectares in the between Cauca, Huila, and in the entire plain. We have precious metals, gold, that have to be theirs, unearthed by, and so this precautionary measure. This is the vital mechanisms to really defend, because what's more important, the economic aspect, life, or the land? I think we have all the tools, and the new tools, legal tools that even the President Petro is trying to hinder exporting a coal from Cerrejón to Israel, and we know why. And it's to take away all the traps. It's really we're trying to coordinate, articulate. The institutions need to be articulated because they're not coordinated. So we do have that social activism, which is vital, because from your action board, you need to begin to defend the right to a healthy environment. Good morning, Ebony, and greetings from Bogota. To ask my questions, our president, he rules here in Bogota. He rules in Bogota, but in the regions of Colombia, the president doesn't have a say, nor the commander of the police general. They have never really, unless they have a direct relationship with the illegal armed groups. This is just to tell you that Colombia has had an armed conflict for 60 years with different armed structure, and in despite of that, we signed a peace agreement. But today there are three large armed structures with more combat, with more soldiers than before. So we have an institutional weakness, administrative corruption, and a conflict that grows exponentially. So corporations or multinationals like BHP, Billiton, and Glencore, Drummond, South 32, the former United Fruit Company, Coca-Cola, Union Feroza, all of them, without exception, their partners or their shareholders have taken advantage of that context of violence to extract our national resources and order the killings of environmental leaders, of civil society, and destroy the environment. Therefore, my question is, how can we have an international campaign showing impacts, for example, of South 32, are at least to link around the world those partners or the shareholders, taking into account that here where they operate, they we have they have never suffered an attack from the armed groups, but there are 50 indigenous leaders that oppose the companies, and all of those 50 have been killed, and nothing has happened to the company. So we don't want to prejudge, but there's been some coexistence or support from this company, whose parent company is in Australia and South Africa, and they have links with organized crime. So how can we really start an advocacy campaign and make shareholders accountable and also knowledgeable on what's going on?
Yeah, it's really difficult. I'm really sorry about the situation in Colombia, and I hate hearing, particularly that an Australian company is involved, because I'm Australian. That is what this work is all motivated to achieve, is to try and regulate multinational corporations that can leave one jurisdiction like Australia, where there are more regulation, and go into another jurisdiction where there's less regulation, and, as you say, problems with corruption, and take advantage of that situation. That's what we're trying to achieve by having some of these mechanisms that happen at the international level, is to try and start regulating these corporations. And that is what my personal work is actually aimed at, is how do we regulate Australian businesses who are doing the wrong thing overseas? Because, as you say, shareholders and the Australian public, they don't know what's going on in Colombia. And I have to be really careful in the work that I'm doing, because I never want to put people who are in the local area at risk with the work that I'm doing, by trying to raise awareness to these human rights issues. But then also, we can't just be silent because we're afraid of the corporations as well. So it's a really hard tension. And because I'm privileged to live in Australia, away from some of these, as you say, armed forces and corruption and that kind of thing, I have more protection. In terms of me personally, I have more protection to do this advocacy work. And so we're trying to create networks at the international level to do some of this advocacy work, particularly for people like Colombian people who are at risk. But it's very difficult, and all of these tensions that you talk about are really complicated and difficult. And if we can create more regulation at that international level, my hope is it becomes harder for these multinational corporations to come into your environment and exploit the situation there. But unfortunately, I don't have any, straightforward answers and everything for you at this point. But I'm just hopeful that any of the work that I'm doing and my colleagues are trying to do will be helpful eventually.
Fine. Good morning. My name is Sor Marina Solina from URE, Córdoba, and I want to ask a question, because your topic really interested me. When you talk about the principles of each country that's trying to regulate, whether they're abiding by the principles, of course, every country is different to the other. But here, you're talking about institutions that promote human rights, and you have the ombudsman and commissions. In this case, in Colombia, what would those commissions be? I don't know.
It's a good question. Was that it? Sorry. I think I interrupted the interpreter. No, it's a great question. And actually, I would like to hear from people in the room. Has anyone had any experience with any institutions in Colombia. I'm not familiar. Because I'm in Australia, my focus is more on the Asian region. So I've never dealt with institution, like National Human Rights Institute in Colombia. But does someone else in the room have any experience with them?
¿Alguien aquí con experiencia en la Defensoría del Pueblo o alguna institución de derechos humanos?
With the ombudsman, I mean experience in having like filed complaints, or would you like to make comments on how it went? I would like to share. I would dare share an experience. There is a platform called La Guajira Speaks to the Country. And that name, that's how it translates. The Department of La Guajira wants to speak to the country so that in other territories they don't go through in terms of what has happened to them. In La Guajira, all internal judicial mechanisms have been activated, from class actions, annulment actions, administrative procedures, even. There's, we have had, and there, 3 multinationals operate with their parent companies in Switzerland, Australia, and the UK. They participate, they have shareholders. If you listen to what those general shareholders assemblies have said, you can see the history of how we've tried to sensitize only one shareholder in one occasion said to our Wayu mother that he was going to sell his shares, and with the money of her shares she was going to donate that money so that she could buy her son the medicines because he's ill because of the coal dust or particulate matter. So we go to the contact points in Australia. We have a panel, an expert panel. This expert panel, they made a report, recommendations that were never fulfilled, and there is a document signed by one of the experts. It says none of our recommendations that we assessed through their complaint were met or were fulfilled. Then we go to United Nations. 7 rapporteurs of the United Nations they wrote their recommendations to the Colombian state, and we finally won a ruling that stops the exploitation of a very important creek in La Guajira, where we have lack of water. It's a very dry area. Now, this ruling, which meant, or the meeting, that huge gathering that we've done amongst many others, and we also filed 3 complaints, and the national point of Switzerland, Ireland, and UK. The UK and Switzerland, they just did away with the complaints. The only complaint that is open now is the one in Ireland. So we resorted to this system to tell the system again that they're useless. So having inputs to tell them this is useless. This is our objective. So 2 of them have been closed, so now we can tell Switzerland and England and UK, so never talk to us again about national contact points. There will be maybe other cases where we have to start the path, as you mentioned. But just to be, I know I'm expanding a little bit, but BHP and Anglo America, they sell their shares. And the owner of the entire company which is the largest open pit coal mine in Latin America, and now is property of Glencore. So it is one of the multinational companies that has open cases of abuses on human rights, territorial rights, and environmental rights. But they continue violating every right. And this multinational company in Peru, in Bolivia, they have sold also their companies to small companies, or we don't know where the capital that comes from. So we begin to, we have to start again to chase that, the money. Why would I like to point this out and talk about Glencore? Because we were able to stop the exploitation in Arroyo Creek. So they went and they filed a complaint against the Colombian government in the International Tribunal, and we've talked about that also. So the problem is that there's so many experiences that enable us to assess and to be quite critical of these systems, to be able to say, face to face, that they don't work, that they don't work with principles or criteria that really pave the way that is just for communities. And I would like to close that there is a ruling in the United States, which I think it's a ruling that all of us should be reading about, because it's the only ruling around the world that told the World Bank that they weren't immune, that they could be sued. So the World Bank is doing consultations to really tell the people, no, we want to improve our principles, we want to regulate our. So this huge bubble, and with the elements that you submitted today, they give us some certainty in terms of the different possibilities or windows that we may have. But we also need to reflect critically in the way that how we assume really trying to go and reach out to those spaces. A proposal that I would make to Roads to Justice is if we could analyze the history around the world has been told as of wars. So that's why sometimes we feel that we're trapped in so many subjects. But what happened if we were to tell the story of the world around pacifist movements? So I'm asking myself the question whether we would need to analyze the permanent tribunal for people, the water tribunal, what other mechanisms, grassroots mechanisms, or do we need to assess? Colombia has two rulings on the tribunal, the ongoing outstanding permanent, one for La Guajira and another against genocide in our country from the permanent. So what other instruments do we need to create or think about in trying to have this critical view of all these systems that have been established? And the response that they've given, the guiding principles of United Nations began to be discussed back in 1970, in the 70s, and they were only issued in 2011. And 10 years after, the conclusion is they don't work. So people say, oh, so let's do a binding treaty. And so the countries, the northern countries, for a binding agreement, we need to have due diligence. And here, the due diligence bill does not contemplate access to justice. Therefore, it didn't work. So what are we doing really in the National Table of Human Rights? We are working on a campaign to have a regulatory framework and a bill that really has teeth. So the corporation, and this is a future task that we have ahead of us, we need to look at a documentary called The Corporation. The conclusion of that documentary is that many companies and transnational companies, they act as psychopaths. They have the characteristics of a psychopath. And there are psychopaths at different levels. Some of them we can treat with national rulings. Other psychopaths, because of their condition, we can deal with them in this non-binding document or non-judicial documents. But when we face otherwise, we need to lock them up. So we need to move forward in that world of ideas around how to stop that psychopath in our territory. I also wanted to make a comment. Let us not forget, in my opinion, the importance of using many mechanisms at one. I don't think a mechanism is one mechanism is not a response, but sometimes we need to use mechanisms even if they don't work, and just to precedent. And what Rosa Maria says, we need to use the rulings of the permanent tribunal for people. No one is saying you have to use this or that mechanism, but it's just we need to assess all possible options. My name is Francisco Ramirez Cuellar. I coordinate a team of lawyers that we file lawsuits against multinational in the civil jurisdiction of the United States, then in England, and then the war crimes and crimes against humanity. So my question is, BHP has committed crimes against humanity and crimes. In the concrete case, in April 2004, paramilitaries paid by BHP Billiton, Anglo-American, and Glencore Strata, they used the platoon paid by the company, which is called the Cartagena Battalion, which operated with paramilitaries paid by the company, by these three companies, but they were hired by these companies to massacre in Bahia Portete, to drive away indigenous communities that had denied to leave that place because the company is required to triple the exports of coal and they needed to expand the port. So my concrete question, in despite of the fact that I think I know the answer, but I want to have a hope because you're also a lawyer and you can guide me. Is there a real possibility that we can sue in criminal courts or civil court those war crimes and those crimes against humanity committed by BHP Billiton?
I'm assuming you mean sue in Australia. There are ways to bring cases in Australia based on what's happening in other parts of the world. So, for example, I acted on behalf of refugees who were held in Papua New Guinea by Australian companies, and we brought a class action and were successful in getting those victims about $90 million Australian dollars in compensation. So it can be done. It's not easy, like everything else, it's not easy. You have to investigate the facts of the circumstances that you're talking about, and I'm not aware of all the details, but there are ways that you can bring cases in Australian courts for what businesses are doing in other countries. And people, feel free to contact me with particularly if there's an Australian company involved, I can look into situations. I'm already working with Susie to investigate another situation in Colombia. I'm happy for people to contact me and I will see what I can do. I have links with Australian law firms who are willing to investigate certain cases, but it is very difficult. I don't want to imply that it's easy. It's very difficult, like all these other mechanisms that we talk about. There was a case actually just in the last 2 days. I'm sure that people have already heard about it, but there was a case in America where an American court held a company liable for murders of Colombian people. So Chiquita, I think is how you say it. Have people heard about this case? I just wanted to mention it in case people hadn't heard about it, but yeah, so I mean that was good news, I guess, that this decision has come out, but I mean obviously they had to wait a very long time for that decision.
Me pregunto si ese caso en el que ustedes están de Chiquita Brands, si los patrones, digamos, que han utilizado ustedes de
used for investigation, etc. Could you perhaps study the patterns that were used in the case of Chiquita and see to what extent some of them could be applied to the Australian context? I think it would be very interesting to discuss this with Ebony. And this afternoon at 6, we will have this firm of Australians that work very closely. They're called Blackburn Morris, and we could discuss this with them too.
About the case of Bahia Portete. This is a case of the massacre that took place after Cerrejón Company announced its expansion project P500, which involved the diversion of the river to access a huge amount of coal. For that, they needed to expand the port facilities in this indigenous area owned by the Wayuu. Okay, no, pero la traduzco yo. Entonces yo traduzco la pregunta. ¿No? ¿Qué pasó?
Hazlo otra vez.
Okay, sorry. Okay, so I'm sorry. I've got to repeat myself because the translator was working. So just adding to Francisco's question, the massacre in Bahia Portete followed Cerrejón, the company, announcing its expansion project P500. This involved the diversion of the Rancheria River and to access something like 32 million tons of coal accessible. For that, they needed to expand the port area in Bahia Portete, which is an area occupied by the Wayuu indigenous people. This led to a massacre, the Media Luna massacre and other massacres around that. So we're talking here about potentially crimes against humanity. So my question is that I thought in Australia, the Australian state does have legislation which allows for investigation or criminal prosecution of companies for international crimes. So just whether you could clarify if that's true or not.
So no, in Australia, you can't bring a case based on international crimes in Australia. What happens in Australia is if Australia signs up to an international agreement, then the Australian government has to create a domestic law to enact the international standard, and then the Australian courts can apply the domestic law. So Australia isn't great with human rights. So what happens is you have to find a domestic Australian law that someone has breached and bring a case based on that domestic law rather than based on the international human rights principle. There's also a legal principle where you have to look where the conduct has occurred. So if the business has done the wrong thing in Colombia, the Australian courts actually have to apply the laws of Colombia, so apply the laws of the jurisdiction where the event has happened. So, for example, the case I mentioned before, where I represented refugees who were held in Papua New Guinea, even though we had an Australian court hear that case, the Australian court had to apply the law of Papua New Guinea because that was the place where the events occurred. So it is quite complicated. You would have to look at several things. It requires quite a lot of investigation to work out whether a legal case can go forward.
Very powerful actors, and this was emphasized by Susie when she said, even so, we have to continue advocating and putting together different strategies, right? Because here in Colombia, we have this situation, we forget the facts very easily. So if we don't continue insisting, nothing will happen. So we have to continue insisting, even though we know that it will take a long time, but we have to continue insisting on those processes. But my point has to do with the micro level. In my case, perhaps we're looking at things at a macro level, international level, but I apply recommendations at a micro level, these recommendations that we're getting from you. These strategies, articulated, coordinated, because they cannot be taken separately, advocacy, well, the different avenues that you gave us, and I took note of them. I always take these strategies to the micro level, to the community level, to the place where we are, so that we don't forget that the point about here is the territory. It's all about the territory, and they have to be applied in our territory. And on the other hand, knowing that we have weaknesses in our community organizations, communities that have been affected by all these things, I was wondering, how could we work on something that could be guided or endorsed by CAHAD, like do some brief characterization of these organizations. I mean, each one of the organizations should begin characterizing the actors that are around them and that are threatening their processes, their environment, their cosmovision, their life, to identify these actors. And in doing so, check who are those partners or allied corporations, investors, but locally, at a territorial level. Because if we don't do this exercise from the micro level, we won't be able to do it at a macro level. And let's remember that the micro level, right there in the different villages, etc., there are this phenomena where you have these X company, but this X company is being endorsed and supported by who? We have to map that. We have to know that if this company is here, who is behind that company? Because if we go and start some action before the ombudsman or the mayor's office, and it turns out that that mayor was appointed by that company. So it's important to know that. Sometimes we know certain things, but we have to do the homework, mapping things at a micro level. Because this micro mapping, if we share them with other colleagues from Valledupar or from the Cauca region, we may find that there are actors that are repeating themselves there, and we can put the threads together and be stronger, because we realize that this is an actor that is not only present in the Brothers of La Guajira, which sounds very strong, but it turns out that in a smaller proportion in Bolivar, those same actors are taking these actions, and it's important to collect all that, because sometimes in the small territories, actions are smaller than in others. So these small actions become faded away, actions that are being taken in other municipalities, and you only look at the emblematic case. But it would be very nice if we could collect all the efforts that are being done, and that can be done when we have a common thread, when we have the truths once or when we have collected the information thoroughly, using the right methods, using the right schemes, and we can socialize them. And this helped us also having the backup and the support that we need from CAHAR or the actors that have been supporting us and accompanying us, giving them these micro maps, telling them, this is what I found in my territory. For instance, we know that the armed actors do not act alone. They report to certain companies, but these companies in turn do not exist by themselves. Let's use a name, Hokol, and I share this with my peer here. Hokol. I cannot think that in my territory, I have this experience, by the way, with Hokol. We had this prior consultation, but Hokol is not alone in all this. But the people in our communities and in our community councils believe that this is just this company, Hokol, and that's it. And if they do not understand that Hokol is right there in the same things with the co-patrol and that they have different operators, I was telling my colleague today, be careful. There is this Hokol operator that was created to do, the whole package. They're the ones that develop the social projects, and they force the communities to be with their foundation, and that foundation is theirs. It was created by a Hokol official. And see how this is all intertwined. But Hokol is present throughout the Caribbean territory. But if we don't start sharing all this information, things are very difficult. We would only be looking at the emblematic cases, we know, with the highest amount of casualties, but there are some casualties here and there that are difficult to have visibility of. Thank you. Good morning. First of all, I would like to ask Rosa for a favor. See if you can share these rulings that you refer to regarding the possibility to send them to banks funding these companies. And the other question that I have is thinking of the judicial tools. I wanted to ask, what's the effectiveness in the, prosecution of environmental crimes, ecocides? I don't know if this is a very basic question. Is there a direct recognition of environmental crimes, as is the case of ecocides? Is there a typification, for instance, because of the disappearance of a river or a species or affecting ecosystems? Or what is there instead is just penalization of crimes associated to this, like the ones that are always mentioned, homicides, displacement? Or has there been any progress in punishing these environmental crimes? And if that is so, if the answer is yes, before which court would you litigate for those crimes with that penal connotation? And I would like to call upon the organizers in a lovely manner, with much love, Susan and Peter. Some rules were established here. There was an agreement that we made here regarding the rules for the good development of our meeting. And I would like to put on the table something that is a rule for all of us. When you give the floor, when you give turns for participation, you're also subject to those rules. So let's respect the order in which the floor is being used, because sometimes you skip that order because you want to make your own questions or your interventions. So I just want to call upon you to follow that rule. Thank you very much for your comment. Absolutely. Ebony, would you like to answer or
So I will get a link to the bank case that I mentioned. Can you guys hear the interpretation going? I don't know if I should. Yeah, I'll provide a link to the ANZ case. And and then in terms of the environmental question, there has been a lot of litigation around the world on, damage to the environment, climate change, all of that. And there have been some effective cases that I can tell you about at the international level. I don't know the details about in Colombia, though. So, for example, there was a case against Shell in Europe where the case said that Shell wasn't meeting their emissions target. Um, and that case was successful, and the court ordered Shell to change their policies to meet their emissions target. So that's one example of a successful case in regards to the environment. But there's a lot of litigation going on about environment at the moment. It's been a huge issue that's really blown up in litigation around the world.
In the legal framework here in Colombia, there is a weakness here because the criminal type says that one which without permission contaminates. So, because permissions have been given to everybody here and there, if you say, I have permission, it means that you can contaminate. Any other comments? I think that our time is limited. Theoretically, we can go to 10:30, but it depends on whether you have more comments or questions. Let me make a clarification here, just to say that facilitators are not here just to pass the mic. We're here to put threads together in between different conversations. And even though we have to respect the different turns, you have to respect the role of facilitators because we have contributions to make just to clarify. But I understand your point, and I will take it into account. So we have about 10 minutes left. We will entertain a couple of questions more questions, and then we will break for coffee so that we can resume. Okay, we're having our snack here instead of going to the room next door. So we have 15 minutes to relax a little or to continue with questions. It's up to you. Let's continue with our discussions. There's another comment. Hello, Ebony. While I was listening to all this in favor of human rights and vulnerations of human rights, I have a question, perhaps based on my own ignorance. Perhaps Ebony can help us or anybody here in the room. My question is, in hearing my peers and my colleagues here, I've come to realize that in other places of Colombia, certain mechanisms have gone farther already than in my municipality, in Morales, in the southern part of Bolivar, where our rights as peasants have been breached. They have breached all our rights with the oil palm plantations and glyphosate spraying, and we peasants have been left with inert land where nothing can be grown, and we peasants live from our fields. The rivers are gone, the lakes are gone because of the oil palm. So my question is, what entities, what organizations could we resort to in order to get resources to help us with a study that could express all this that is happening before the government? That's my question. Thank you. I wanted to emphasize these terms, licenses and permits, which in mining, we're talking about tons of them. Yeah, or we're talking about tons of material. If you're going to be mining more than 2 million tons, I think it has to do with the National Mining Agency that will be granting the concession. And then it'll be the National Authority on Environmental Licensing that will have to see this. And the territorial corporations will think that they don't have to get involved when they do. And another thing that we have discovered, and something that we're trying to tackle directly to have it revoked, is to ask for the nullity of the titles given in those areas, the mining titles for Libero copper that asked for it. That's when the sale of the Colombian state started to be done to these mining company, Ibero Copper. It's a concession. It's a legalized permit, quote unquote, legalized, meaning that they bribed those corrupt officials since then. And since then, since President Santos, I remember these mining train engine that came about. And before that, there were national policies on this. But they never realized that they should have used the Constitution in Article 79, in the right to healthy environment, etc., and through the Law 80 about contracting. I think it's Article 44 in the Constitution. There is a section somewhere that says that if it goes against higher norms, that contract has to be declared null and void by the decision or at the request of the environmental authority. One thing, and let me finish with this. The permit or license or the legalized. One thing is the legalized permit, another thing is the legal nature of it. Check the internal legislation in the mining agency. The participatory right, that is in the legal framework of the constitutional preamble, the values, and the democratic, legal, and participatory principle. This is very strong. The universal principle of human rights, citizens' participation, universal citizens' participation under Article 21 of our Constitution, of our Charter. That's where we can start discovering what we are and what we're made of in the defense of our rights, dear colleagues and peers present here. So we want to say goodbye to Ebony because it's quite late in Bangkok now. And we want to thank you, Ebony, for your presentation and for the dialogue that we had with you. As you can see, there are people in the audience that would like to continue talking to you, so we will be distributing your contact information so that this can happen. Thank you.
Okay.
Thanks so much for having me. I hope you enjoy the rest of the forum together. See you.